Welcome back, everyone. I hope you all had a good break and are ready for our next and sadly final panel, which is on the topic of a global approach to bank insolvency. Our moderator, Fernando Restoy, the chair of the Financial Stability Institute, will introduce his expert panel. Thank you. Fernando.
Thank you. Thank you very much. Good afternoon, everyone. This is the final panel of this interesting, important conference. It is on banking insolvency frameworks. I think you would agree until recently, sort of the insolvency or liquidation was considered like the poor cousin of resolution. That, for good reasons, of course, after the great financial crisis, there was much work to try to put together some reforms of the bank failure management regime for systemic institutions. So there was no comparable actual exercise for, the bank failure management regime in the case of medium or small-sized institutions. So the consequence, of course, is that we have now a wide diversity of regimes in different parts of the world. There has been some work in the area of commercial insolvency regimes, but of course there has been nothing specific so far in terms of banks insolvency regimes. So this leaves a gap that I think matters for a number of reasons. First, of course, we all agree that banks are special, and not only systemic or large banks are special. No matter how large the bank is, that the functions that they actually provide in terms of taking deposits, in terms of facilitating credit to the real economy, in terms of obviously being involved in payment processing, all those things actually are relevant functions with a social dimension. And in particular, when the bank fails, of course, there are some public interest implications that should actually be well understood. In particular, some of those implications have to do with deposit protection, which is obviously a social policy goal. And of course, deposits, or part of the deposits are protected by deposit guarantee schemes, but the liquidation, good insolvency regimes can be a good complement of deposit insurance schemes to facilitate, for instance, continuity of access to deposits, to facilitate a rapid actually payout of the deposits when needed. And it's hardly the case that regular, ordinary insolvency regimes could actually sort of deliver that. And the same could be said of the potential for the failure of a bank to generate some sort of contagion effects on other banks, over the same sector, the same region, or whatever. That's why it's important that the liquidation actions take place in a expeditious manner. And again, it's not the case normally that regular insolvency procedures could actually deliver that. But also, I think it's important to bear in mind that the bank insolvency frameworks need to support resolution. When a bank is resolved, in many cases, some parts of the business of the bank are actually wound up by means of regular insolvency procedures. It's important that the liquidation procedures are fully compatible with the objectives of resolution. And sometimes, people in this room, of course, know this very well, insolvency regimes contain elements which are very important for the application, for the implementation of resolution frameworks. And the good example, of course, is the creditor works of principle, right? So you really need actually to have a relatively clear and transparent outcomes of liquidation in order to facilitate the application of this important principle, which is part of the resolution framework. There are many reasons why I think we should care about banks' insolvency. And I think it's fair to say that in the recent past, there has been growing interest on this matter. Certainly in Europe, this is the case, but it's an ongoing debate, as you all know, on trying to improve the crisis management framework, following a very important, helpful, I think is well thought proposal by the European Commission, the crisis management and deposit insurance proposal. Of course, the objectives of this CMDI actually goes beyond insolvency. It's true that it addresses a little bit some frictions between the national insolvency regimes and the common resolution framework, although of course it falls short of trying to propose a sort of a harmonization of insolvency regimes across jurisdictions. So against this background, we have a project developed by UniDroit, precisely on this, on banks' insolvency regimes. It's a legislative guide. It is the case that the consultative document of this project was just released yesterday. So it's a great opportunity, actually, just to discuss actually the contents of that document. At the FSI, we are very proud to have contributed to this project from the very beginning. We started working or talking, Ignacio, you remember that, for 2021? Yeah. So after that, we have been actually supporting the UNIDROIT Secretariat in coordinating the exercise, and we have, of course, been involved on the different phases of the project. At the FSI, we have this mandate of trying to support financial sector authorities worldwide in strengthening the financial systems. So we have a number of interactions with authorities worldwide. And we have perceived clearly this appetite, this demand to have an international reference to deal with the crisis of smaller banks to complement actually what the FSB has done for systemic banks. So it's great that we have now this consultation document with us. There are now like 3 months or so to receive comments. So I think it's a wonderful opportunity actually just to be exposed actually the main recommendations that this important document contains, and then to discuss the different aspects of the document, leveraging the great lineup of speakers that we have in this panel. So we'll start with an introduction by Ignacio Tirado, who is the Secretary General of UNIDROIT. You all know him. He's obviously one of the main promoters actually of this exercise. And I must also say that he's the pen holder, actually, right, of the. So it's very important to hear directly from him, actually, what are the main purposes or the main contents of the consultation document. And then after this presentation by Ignacio, we'll have a series of intervention by our panelists. We'll start with Elsie Awitsi. She's Deputy Governor of Central Bank of Ghana. We also have David Ramos, who's professor at Universidad Carlos III in Madrid, and my colleague at the FSI, Ruth Walters. So we'll start with Ignacio, then we'll move actually to Ruth, who is going to discuss about the institutional aspects of the document. Then David will cover mainly the technical aspects of the document, including issues about creditor hierarchies, about liquidation tools, etc. And last but not least, Elsie will talk about funding, possibility of getting actually public support, issues relating to financial stability in general. The idea is to be very interactive so that all panelists will be invited actually to intervene for any of these components of the discussion. For sure, we'll have time to get questions from the audience. So with that, Ignacio, what is there?
I'm going to do it from here. Right. So good afternoon, everyone. Thank you, Fernando. First word of gratitude to the Single Resolution Board and to Carl Philip for all the support. I should say the SRB is not just hosting this first consultation event, but it's actually worked very closely with us throughout the entire process. So much so that we did one of the sessions of the working group here, hosted kindly by the SRB. So thank you very much. Of course, big thank goes also to the FSI, to Fernando, to Ruth, to Rasko, to the Financial Stability Institute of the BIS. And I believe this is very, very important, the fact that they walked this path very closely with us, because UNIDROIT, which is, and I must say it to this crowd because some of you might not know it, is an intergovernmental organization with 65 countries, which represent 75% of the world population, but more than 90% of the world GDP, of the world economy, so it's quite an international organization. But what it does is private law. And normally resolution and liquidation of banks was the exclusive realm of Basel institutions and our regulators. Therefore, the fact that regulators partner up with private law experts, corporate law experts, insolvency law experts, is a unique exercise. And I think it's important that that you understand that the result of this guide is the blend of these two perspectives. Of course, ultimately, like with financial stability, whatever the regulator says is the final word, but we try to show a different perspective anyway. And I should also thank the SRB for allowing that a global panel has an absolute majority of Spaniards in it. It's a very good idea. Doesn't happen that often. Okay, as was already mentioned, one of the reasons for this project was the fact that although following from the crisis or after the crisis, or the big financial crisis, as you want to call it, the Financial Stability Board and generally the financial institutions, international financial architecture developed the key attributes and a number of regulatory texts which cover very well systemic banks. At the same time, we already had before antitrust efforts on corporate law, corporate insolvency law, which were very good ones. Therefore, there were standards both at the systemic level for banks and also for corporate law, corporate insolvency law. But there was nothing for the small banks, for that smaller part of the sector, where financial stability and banking regulation meets hardcore corporate insolvency law and private law rules and pure hierarchy and liquidation. So there was a gap in the regulatory standards, and that's what we tried to do. This was started as a proposal from the European Banking Institute. Many people in this room belong to that, as did I before I put on my current hat. So I'm now suspended from participating. And the Bank of Italy. Bank of Italy was instrumental at starting with this project, and then many others joined. The text is a global text to the extent that it involves the very active participation of the IMF, the World Bank, and around 39 to 40, I forgot exactly the number, although it says 39, I think it's 40, institutions, either resolution authorities or deposit insurers or supervisors. We have the European Central Bank, we have the Bank of England, the Bank of France, the Bank of Spain, the Bank of Italy, and the Bank of Ghana, Bank of India, Bank of China. So we have a global representation, which we believe is also very important when it comes to getting the feedback that provides a result which is global. I should say that at the beginning, because my purpose and my added value in this presentation is to be a little bit provocative, is to tell you that the main problem, perhaps, or the main difficulty in the process of the drafting of this was to get so many of the experts to try to snatch away from their head the European BBRD structure, which was very much engraved. So anything which was not the European BBRD structure was not comprehensible. And everyone thought with those terms, when what we were trying to do, of course, is produce a global instrument which would also learn a lot from a single track regime from the United States experience, Canada, and so on. So that was a learning process, and I think it went ultimately very well. Another thing I want to say from the very beginning is also the fact that we are not trying to produce a standard which revises anything. We just complement what's out there. Anything in this guide which might seem to be contradicting the FSD key attributes, the YATI principles, or anything which is established best practice has been read inadequately, probably because we drafted it inadequately, but it's not the intention at all to contradict any of the existing standards. That hasn't always been easy because the key attributes, as you know, are more of an umbrella instrument. They're very broad. So in some ways, they say much, but they say little. So you need to be in a position in which you are able to contribute while not contradicting anything that the key attribute says, and that's a difficult task. But I think we did a good job, and there was the result is quite balanced. The final subjective scope of the guide is referring to non-systemic banks that are not resolved pursuant to a resolution regime, and or parts of a bank following a resolution regime after what remains of it, or in the context of it, a separate entity. That still should cover a very important amount, a very important number of banks, at least numerically around the world, and the smaller the jurisdiction, likely to be the larger the importance of the instrument. We take account, of course, of the existence of single track and dual track regimes, and try to be neutral as to one system or the other, although we will see when we talk about institutions that there transpired slight preference for an administrative model, although this was subject to a strong discussion and is still open for discussion. And the document, which, as I said, is very balanced, is trying to provide quite a lot of flexibility for countries to adopt. It's a legislative guide, which means it's a normative instrument. This is the jargon of transnational law organizations. It's a normative instrument which provides different options, pros and cons of those, and some recommendations wherever there is a preference, and key considerations. This is the type of instrument which we produced and which we are producing, and which will, of course, has as a target reader a legislator from a country. So we can take it as a standard in its own country if it's looking for some additional external guidance. An interesting part of the project is that it does get into the model of analyzing objectives of the liquidation regime, and I've identified there, I think you can see it, the classic ones, because liquidation is directly related to necessary rate of the payment of creditors, the maximization of the assets has to be one of the objectives, as it is clearly the main objective in corporate insolvency regimes. That might at some stage, rarely, but can run counter the other objectives, such as financial stability and related objectives, such as depositor protection, or minimizing cost to taxpayers. In principle, what the guide says as well, maximizing value is a key in the document, and is something you should pursue in your own system. But should there be, which is something which, as I said, is much less likely to happen here than in an entity under resolution, there could be a decision where financial stability would recommend that you do something, take an action which doesn't maximize value in a given moment. That can happen. So in those cases, financial stability trumps, in principle, any other. But this is all still up for discussion, and this is the way things are at the current state of things. So I think I have still around 5 more minutes, so I will get into a little bit some of the selected aspects. We do detain ourselves. I think I've lost this. Can you still hear me? Yeah, okay. On the institutional setup that Ruth will comment on now, as I said, overall, an administrative model might seem to have more benefits than, or be the preferred option. That doesn't say that if you have a court-based model, you have to change it. We'll see about that. But if you don't have any model, you might as well consider picking one which is basically administrative for a number of reasons, allows for better preparation, expertise, efficiency, access to information, and ability to take decisions are better. The more, it's only natural. If one is acquainted with the corporate insolvency regimes of your country, you will see that the system, even if it's a very streamlined and efficient one, is not apt for a bank, at least not directly. Yeah, sorry. You know, I'm Spanish, but I've been living in Italy for so long that I move my hands a lot, so in principle, this would be the main idea. However, if the solutions are based, or the country has a system which is based on a court on a court system. There are different degrees of court intervention, of course, but when that is the case, what the guide says, well, if you intend to preserve a court-based system, you have to make sure that a number of things happen, that the administrative authority has the ability to step in and provide and acts in the process, at least at the beginning or during at the time when a transfer is to take place. It intervenes in a moment of appointment of a liquidator, if there is one. That happens in many countries, or it can even itself be appointed as such. It provides guidance in the decision-making process. So fine, get a court-based system, but make sure the administrative authority is present, especially for those decisions that are key and where the administrative authority has the special expertise and has the background which is more adequate to take the decisions. As to liquidation tools, if you come from the corporate insolvency world where liquidation tools are what they are, basically selling things, this is a different approach. The approach here is, of course, that of trying to, similarly to what modern corporate insolvency regimes do, which is trying to sell the business as a going concern to the extent that there is added value to it, a goodwill in the business. Similarly to that, the transfer of the business is a preferred possibility in the guide, and quite a lot of attention is dedicated to it. It's important to notice that the guide provides guidance as to the rules that need to be approved outside banking regulation so that the going concern transfers can take place validly without, for example, requiring the consent of the counterparty to a contract or the shareholder, because we are in a liquidation. So those things which are now starting to be evident in corporate insolvency should be absolutely the key in a bank insolvency transfer. Having listened to the wonderful prior panels, when I heard the final outcome of the discussion regarding, for example, the bridge bank in our instrument is very moderate. It's like, well, you can have a bridge bank, but not really, because it's not for a liquidation. However, and this is up for discussion, and we'd love to hear the people in the room. Listening to the discussion below, it seemed to me there are many ways in which a bridge bank can be. Think of the Japanese system where you have pre-established bridge banks with a license already ready to be operated. Think of the American model where you don't need special capital because there are other ways to ensure that it's up and running in a consistent way. Perhaps with those types of regulations, it might be possible to consider that bridge banks could be useful in a liquidation scenario. It's possible in the guide, but it's certainly not advised at all. Something similar happens with asset management or bail-in asset management companies, which are linked directly with a situation of widespread problems in the sector, or bail-in, which is directly seen as a resolution measure, full stop. So we don't get into that part at all. The more boring part of insolvency, but which requires, of course, some guidance, is the piecemeal liquidation part. And there we provide guidance as to a number of specific rules would change what normally would be seen in a corporate insolvency liquidation system. For example, concerning the proof of claims, which is a nightmare in corporate insolvency law. There are many ways to do away with that in the context of plan liquidation. Contracts, the way contracts are signed, is also an area where we can provide or we advise for the provision of special rules and naturally protections in terms of avoidance of transactions and avoidance of certain operations done in the context of the crisis solution. Very quickly, funding is envisaged and required, especially for the transfer. And we observe the different possibilities with the different types of interventions of the deposit insurer. Very important, a lot of attention is allocated to the discussion on hierarchy. Hierarchy if there is an area where hierarchy is key, it's in liquidation. That's where hierarchy plays the real. That's where you actually have to see who gets paid what. So where the allocation of the ultimate proceeds takes place, and that from an ex-ante perspective, if especially in international cases there is no consistency as to the ranking of claims, there could be a problem ex-ante in determining the TLAC, the MREL, and that's not necessarily discussed in the guide, but this is something which needs to be considered as well in this area. And perhaps the most, or one of the most one of the items which was discussed most in detail was the priority of deposits. And in the current situation of the guide, there is a preference for some sort of preference for depositors. There were important stakeholders participating that prefer not to have any sort of preference. This is a very topical discussion also here in Europe, and comments on this point would also be very much welcome. One last point, and I'll leave it here. A number of safeguards are envisaged. One of the things that I think is key is that precisely to avoid the problems that you see in corporate insolvency systems, while the parties should have the ability to challenge decisions and to appeal, none of that should really have the possibility to suspend the decisions or to interfere with the quick solution of the liquidation of the bank. And the preferred solution, instead of undoing or avoiding an action, would be compensating for the damages, a different type, which is less invasive. So all those things are analyzed in the guide. There is a prescription for the respect of the pari passu rule, but there could be exceptions for that, especially with regards to depositors. And in those cases also, as the main safeguard is no creditor worse off, which everyone is very familiar with here in Europe. And I could say some more, but I think I'll leave it here. Is that okay?
Great. Many thanks, Ignacio. Very helpful overview of the consultation document, all the work you have conducted over the last couple of years. There is quite a solid document. That is for consultations. I think it's clear that you set out a number of important issues for which you are sort of gathering comments from all different types of stakeholders. So administrative versus core-based, issues about liquidation tools, piecemeal, transfer transactions, different types of transfer transactions, issues about creditor hierarchies, funding, a number of things that you have already stressed. Now we have time actually just to cover them one by one, essentially. So we'll start with institutional issues. Ruth, this is your job, is to try to basically to dig deeper into this particular part of the report.
Of course. I mean, I don't have a presentation, so shall I sit here or do you still want me to go to the podium?
I understand. I think that's fine.
Okay, fine. I mean, Ignacio has already, I think, given the outlines of what the legislative guide is saying on it, but I'll, as Fernando says, dig a bit deeper. We've got two concepts which run through this guide. One is the difference between single track and dual track frameworks. Ignacio has referred to that. The single track framework is basically something like the US framework, where for banks there's a single legislative regime which applies to every bank. For the dual track framework, the EU is the classic version of that. You've got a separate statute for resolution, and then you've got insolvency, liquidation dealt with under a different framework. And the guide tries to accommodate both those models. And intersecting with that difference, we have administrative and legislative. So those are the two kind of concepts that help the way we think about it. Single track frameworks there's a strong presumption that they're going to be administrative. If a country's implemented the key attributes and the key attributes requires an administrative resolution authority, that suggests that you're going to have the whole thing being administrative. And we know why resolution needs to be administrative, the public interest in taking actions which may interfere with creditors' rights, the need for speed. Liquidation is included in the key attributes as a potential tool in resolution, but the key attributes is actually neutral as to what the form the liquidation is going to take, and it doesn't assume that the liquidator is going to be performed by the resolution authority. So the key attributes don't actually point in any particular direction. And as Ignacio has said, the legal guide isn't prescriptive as to the format of the frameworks, single track or dual track. We're not trying to push countries into a particular direction there. But it does recognise, I think it's fair to say, material benefits of having an administrative framework. Ignacio might have underplayed the extent to which it maybe favours the idea of an administrative approach. An administrative means that an administrative authority is the main decision maker. And that policy direction is based on several considerations, which are probably fairly obvious, but I'll summarise them. First of all is the speed. Like resolution, administrative authorities can generally act more quickly and more decisively when that's needed. And that's coupled with what might be seen as their superior knowledge, both of individual banks, if they have supervisory functions, and of the banking sector more generally, which might help to inform their decisions about the liquidation strategy. And they're likely to have far greater access than a court or a private insolvency practitioner is going to have to firm-specific information, and that's going to help with expediting the proceedings. Second are the objectives. Ignacio has mentioned that in addition to the conventional objective of value maximisation, we have public interest objectives, particularly creditor protection, because we're talking about banks. That's absolutely vital. Financial stability considerations. I think there's a discussion to be had here, and we've had it extensively in the working group about what financial stability means in the context of liquidation, particularly when you've got a resolution framework which is meant to deal with financial stability. But there are going to be public interest considerations, and administrative authorities are likely to have some kind of financial stability public interest mandate, which is going to inform their decisions they take under a liquidation framework. So again, the having an administrative regime supports those objectives. And finally, preparation. If you're going to do something like a transfer, a sale of business, David will talk more about that, is going to need preparation, and administrative authorities are in a better position to be able to start that at a much earlier phase than you're going to be able to do under a court-based system. And we see the US regime is a good example of that. The FDIC can march in advance and start preparing for a P&A. So, and then the drawbacks of a court system broadly mirror those, but I'll go over them because I want to touch on maybe some of the mitigating factors you can have there. So speed. Courts are almost certainly going to be a lot slower. Coupled with a lack of specialist knowledge, they just don't have the access to the information that the administrative authority is going to have. These can be addressed, they can be mitigated. You can have specialised courts if you can draw on with judges with particular sectoral knowledge, sectoral experience, drawing on a pool of experts, and you get that in the more developed financial markets. So this isn't an absolute deal breaker. And courts can adopt expedited procedures, and we know that there are countries that can act quickly. So not impossible, but we also know that there are countries with court-based insolvency regimes that really are not nimble and cannot act quickly. So this is going to be quite jurisdiction-specific. The objectives, well, courts really aren't well placed to deal with those public interest concerns. Again, this can be mitigated to some extent. I'm thinking in particular, an example, something like the insolvency regimes of the Republic of Ireland and the UK, which are court-based but have within the framework a procedural priority. So when a bank's put into liquidation under the bank liquidation or bank insolvency procedure, the liquidator has a clear mandate and objective to deal with the depositors first. So you can put something into your regime that helps address those objectives. And finally, preparation. Significantly more difficult under a court-based model. Mitigants could be the provision for a provisional liquidator, but that's not going to it's not going to make it comparable to what can be done under an administrative framework. But as Ignacio says, the legislative guide does recognise that jurisdictions have court-based and may have legitimate reasons for wanting to retain those. It's either going to be something constitutional, or they may take the view that, well, our court-based system works, we've made it work, we've got the specialised courts, and they don't particularly want to add those additional functions to an administrative authority. So we are going to have court-based frameworks. So the legislative guide deals in a bit more detail about measures to mitigate those, and those are basically trying to insert an administrative authority into the procedure at the stages when it matters. When I was talking to Fernando about this, he says, well, you're trying to turn a court-based regime into an administrative regime, and that's kind of what happens. And particularly in the earlier phases of the process, so that's the entry into liquidation, the decision to put something into liquidation, the decisions about the liquidation strategy, and about how those key objectives, depositor protection and any financial stability considerations, are going to be pursued. So for the opening of proceedings in an administrative system, well, this obviously falls to the administrative authority. In a court-based system, the guide advises strongly that the administrative authority has a significant role in it, either that the competence to open the proceedings is solely on the administrative authority, which is possible. In some countries where it's seen as sort of constitutional that creditors should have the right to open proceedings to enforce their claims, then a right for the administrative authority to be consulted, to be notified, to be heard, however it's framed, to make sure that the views of the administrative authority are going to be taken into account, if only because the administrative authority may be taking separate actions, or maybe thinking about putting into resolution. So these things need to be brought together. Administrative authority could also be involved in the appointment of the liquidator, in the determination of its remuneration, represented in any committees which are overseeing the liquidation. So making sure that it has oversight and some degree of steering. And I think to the extent that there's a piecemeal liquidation of the assets, the case for the involvement of an administrative authority is less compelling, and the advantages of court-based proceedings there are probably more equally balanced. Also in the later stages of a process where they're dealing with the distribution of proceeds to creditors, and arguably courts and insolvency practitioners there are at least equally qualified and maybe even better equipped to deal with balancing the private interests. So the way the guide sees it is you really need some kind of administrative authority involvement early on. Later on, there are maybe courts have a better role in it. Couple more points. Ignacio's already covered it, but if you have an administrative system, it doesn't exclude court involvement entirely. Judicial review is going to be important of the administrative authority's actions. There needs to be provision for that, but also challenges to court. So the court is going to be there, but the decision maker is going to be the administrative authority. And finally, the guide doesn't really say anything about which administrative authority, if you have an administrative system, should be the liquidator. That's really going to depend on the national institutional arrangements. It could be the supervisor. It could be the resolution authority. It does say something about the deposit insurer, because the deposit insurer is another candidate, and we all know there are frameworks where the deposit insurer is in charge of bank liquidation. But that needs to be matched with the appropriate mandate for the deposit insurer, and equally importantly, the governance arrangements, because if you have a deposit insurer that has private sector sort of active bankers on its governing body, then it's really not appropriate that that's going to be involved in bank liquidation. So the guide discusses that. So I'll stop there, but I think that's the direction it's going in on the institutional arrangements.
Okay, very good. So you have been informed of this delicate balance that was actually sort of established in the consultation document. Preference for administrative regimes, but not certainly banning actually court-based regime, as long as the court-based regime becomes as close as possible to an administrative regime. Sorry to caricaturize a little bit. Any reaction, even asking members whether they would like to add something on this particular issue of institutional arrangements?
No, me? No, I agree with everything she said.
We tend to
disagree, Ignacio.
Tend to agree, but that's the problem. Got the four co-authors of the report here. Any question from the audience? Maybe some reaction, quick reaction to this point of institutional arrangements? Administrative versus court-based? No? Okay.
That's very nice, because we did get some comments from...
Question from the online audience.
Okay, let's take it now, why not?
There you go.
Let's see if it is a good one. I'll try to read this thing out. Could you please elaborate on the dual track regimes you taken into account in designing this framework? I think it's more like what we are discussing, right? Well, why don't we move on to the next the next presentation? I think you should a bit looking at the different.
Hay una pregunta por ahí, si querías, pero.
Paco.
Thank you. Thank you for the presentation.
Fourth Spanish participant in this session. Okay.
Yes. No, very quick. More an observation than a question, but open to hear your views on this. When we compare administrative and court-based procedures for this, I would say that the speed is a very quick angle. So, and the open question could be: are the courts really prepared to deal and solve liquidation dealing with a financial institution, especially if it's a big and relevant banking institutions, at the speed required to avoid all the problems that could create in a slow solution? And I really doubt on it. So I think we have some, very small to be honest, but we have some recent experience, as you all know, probably in Spain, dealing with a court in a liquidation of a small bank. And with that experience, I would say, well, deposits rights are granted, but the procedure itself is not feasible as such. So I really would say that probably if you put the speed on the table, some kind of administrative regime is always a better solution. Thank you.
Okay, supportive comment on the consultation.
Supportive. Yeah. You agree with the guide?
Yeah.
Okay, let's move on. If, of course, have questions about this very issue, we can actually take them at the end. Great. So, David.
Thank you very much. Fernando, can you all hear me? Okay. So just to just capture the intervention and reflect what some of us at least have learned from the process. There's a quote from Norman Douglas, who is a novelist. He said, "Never take a solemn oath. People will think you mean it." And I say this because I believe that bank crisis management has to be serious, it has to be grave. But I realize that with all the process surrounding resolution, we have turned it into something very solemn in Europe. And something we realized early on in the process is that a lot of the tools and the technical aspects, when you have to deal with bank crisis management, call it bank insolvency, liquidation, whatever you will, are draw a lot from the experience of bank resolution. So you have to, instead of talking about constantly systemic risk or critical function, something like that, you talk about efficiency, expediency, value maximization, depositor protection, and you arrive at a lot of the same solutions, at least when it comes to these technical aspects. So I will try to briefly cover some of these and leaving most for the discussion: tools, creditor ranking and hierarchy, and some final reflections. When it comes to tools, so one important aspect was already mentioned by Ignacio. It was essential to acknowledge that the authority needs to have the power to transfer assets and liabilities without obtaining third parties' consent. So that was the keystone of the system. Without that, it cannot work. But at the same time, we realized something that was mentioned in the first panel this morning. You can't have bank crisis management without market appetite. And for that, you need to reassure the parties that may be on the other side of the transaction if you are transferring assets and liabilities of the institution. So if on the one side you have discretion in the choice of tool, you need flexibility. You need flexibility also on to define the transfer perimeter. You also need the possibility to have different types of arrangements, so that different types of transfers of certain asset perimeters, assets and liabilities, deposits plus some assets, etc., can be transferred so that you can cater to the needs of what is the demand out there. And that is also essential. That's why the guide also includes provisions on information sharing, the possibility of conducting due diligence. It advises on the advantages of valuation, but is not overly prescriptive. It has to be instrumental to achieve the goals, but at the same time, what is necessary is a proper process for transferring, a proper process for auctioning the bank, if you will, obtaining offers and obtaining something close to a market price. At the same time, those aspects that go in the direction of flexibility, expediency, efficiency, must be tempered by the necessity of safeguards. So no creditor can be left in a worse position than it would be in a piecemeal liquidation. So some of the calls for discretion, expediency, etc., are tempered in that direction, and that is the framework, the matrix for decision-making for the authority. There are also provisions on piecemeal liquidation where we indicate what should be some of the liquidator's powers to marshal, protect, and preserve the failed bank's assets. That may be taken for granted in some jurisdictions, but this is a global guide. Establishing the estate's financial position, determining the validity and priority of claims with the possibility of relying on bank records for some purposes. And we also conduct an analysis of to what extent the bank liquidation regime can draw on general business insolvency law for certain provisions, the protection of the estate, stay on enforcement, contract termination, with an emphasis to ensure the continuity of essential contracts, because otherwise the banking business doesn't work, and then transaction avoidance with the possibility of stricter rules for transfers to related parties. So how do creditor hierarchy rules can support this? So early on, we saw that there is no need to go into just every specific class of creditors, but at the same time, some bank-specific exceptions are warranted. Those can be included as exceptions per se, or those can be included in a codified way with its own creditor ranking for banks. Those are the two preferable options that the guide advises. And then, of course, there was the part on depositor treatment. This was discussed at length because there's a lot of variability among jurisdictions, but the consensus of the group identified compelling reasons for some form of depositor preference, and then it provided the pros and cons of different mechanisms or different regimes of depositor preference when it comes to transfers. We indicated that a super preference may limit the possibility of the deposit insurance scheme to contribute to a transfer strategy, which may undermine the possibilities of value maximizing. And we indicated also that the absence of preference may create legal challenges to a transfer of part of depositors or some or all depositors to a new viable institution, which is essential to stabilize the situation. We also consider the possibility of, we also consider the regime of subordinated claims, which in the case of the bank context is very important, and we advise on the admissibility of contractual subordination. And we offer different possibilities for the treatment of related party claims, also stressing the fact that subordinating related party claims cannot just be a remote possibility. Either it is expressly contemplated or it is based on principles, but those principles cannot be something applicable only in cases of fraud. Finally, some reflections. We have to thinking, when we thought about bank liquidation and bank insolvency, we are thinking about resolution of crisis, if you will. So thinking in resolution in these terms, I think is a healthier approach when it comes also to bank liquidation. Of course, our advice has different implications for dual track and single track regimes. Principles like value maximization, depositor protection, etc., all require swift action and adequate tools. And the way to compensate this is to offer adequate safeguards. But putting lots of procedural obstacles in the way of decision making is not going to make the situation better for any creditor at all. Finally, we indicate that different options are possible, but jurisdictions must be aware of the implications. So sometimes we advocate a clear line, but sometimes we indicate that jurisdictions may choose, provided that they know what they are signing up for. So those are the reflections on tools and hierarchy, and happy to receive comments and questions.
Okay, thanks a lot. Very clear. Any comment here? Question? Of course, in this aspect of depositor preference is where you are basically getting to one of the hot elements of the current debate in Europe about the CMDI proposal, right? So the guide is very clear about some sort of depositor preference, much less clear about whether we should go for something like a general depositor preference rule rather than super preference, right?
Well, I mean, the guide clearly advocates some form of depositor preference, and when it comes to transfer, it's clear that certain forms of depositor preference, like tiered preference, diminishes the possibility of the deposit guarantee scheme to contribute to the transfer and may end up undermining the possibility of the transfer. So it is, those implications are there.
But you don't close the argument, right? This is like saying, well, this is obvious, right? Basically, you have this tier type of regime is going to provide obstacles for the transfer transaction.
Yeah.
But you don't say something like this is sufficiently strong argument just to go directly for this general depositor preference rule. And just to understand again the balance you're trying to strike there. So it's been in the headquarters of the SRB. The SRB has been quite vocal. In this respect. So, Carl Philippe, may I give you the floor? What do you think about this?
Oh, they agree with everything.
We were, of course, part of this the working group in Unidora, but obviously, I think the Commission proposal, which is on the table. But clearly, the Commission proposal is very much supported by the SRB, and the proposal regarding the depositor preference, the simplification, and the super preference is expressed there.
So the thing is, if I may add, there is no, because there is no express determination that depositor preference is a standard. You don't find it anywhere. The IMF has papers that say it, but it's a paper. It's not an express statement of the IMF, and therefore the countries that disagreed with that approach identify that as well. The IMF might say this in a paper, but it's not in an official document. So you can't say that the IMF advocates, because those papers expressly say this is not necessarily the opinion of the IMF. And this is an open discussion, and although there seems to be a majority, if there is another, there are other parties that disagree, you have to reflect it in a guide in which is you reflect the preference of the majority, but you can't say it as a clear standard where everyone is in agreement.
And I would say,
Pedro, please.
Thank you very much. Well, Fernando, you are asking a bit the views of the SRB. Let me maybe just compliment you what Carl Philipp said. If we are really keen in addressing in an effective way small and medium-sized banks' crisis, I think we should be a bit maybe more ambitious in the banking union. Just fragmenting or splitting into different layers, general depositor preference, we know where it's going to end. We are going to diminish very much the possibility of using the DGS to bridge the gap in the cases where it is needed. So, I think we can, I acknowledge that the IMF might have a paper, but we have also to have a certain conceptual approach towards the best way that we want to efficiently manage crisis. And if we, in principle, want just to stick to a conception where we cannot treat depositors equally, but for some reasons that are also understandable and eventually defendable, but we have to split in different layers, we know that we are going to diminish the effectiveness of handling crisis cases. So it's a trade-off. We might stick to this multi-layer regime. What we are seeing goes even into maybe the opposite direction. We are going to have several layers. We have maybe a bias towards putting certain deposits of large corporates together in the same layer as households and SMEs. These are, of course, stances that are respectable, but we have to be conscious that at the end, the outcome is going to be much dismal when it comes to address effectively banking crisis management. Thank you.
Okay, absolutely. I think there is a clear agreement, at least from this. We have been discussing this actually for years, so you know that well. Now is the time for politicians to discuss that as well. Probably the next legal conference, we can discuss the final outcome, actually, the agreement actually by the politicians, we'll see. Okay, anything else, anybody else would like to intervene on this? Otherwise, we move on. I think we now go to you, Elsie, so we can actually cover the issues about funding, which are also quite interesting.
Thank you, Fernando, and let me say thank you to the SRB for inviting me here. It's good to see friends from the work that has been done by UNIDROIT, as well as from my days at the IMF. And the discussions so far have been very interesting for me. So it's interesting, Ruth has talked about institutional arrangements and etc. My colleague here has talked about the creditor hierarchy related issues. And then I come in with the funding issues. And really, it doesn't matter where you stand on this. Funding is always going to be, I think, the most complex part of things, right? And it is extremely important, even in the resolution context, but also if you take the view that we're working on a liquidation regime for banks that may not be subject to a resolution regime. Funding or failure management, as it is that we eventually called it, is extremely important for a variety of reasons. Now, how much funding is required depends very much also on the triggers, at what time liquidation is being triggered. All right, if it's been triggered early enough, where there's still some value, some net value, then all the better. You have even less of a funding need. There would always be a funding need to pay for liquidation expenses as well as claims, settle claims. But if it's triggered too late, then you're already dealing with a very difficult situation. And then you have to think of issues like burden sharing, what burdens can be shared, how much of these liabilities can be built in, if at all, either from a statutory standpoint or a contractual standpoint. Does the liquidation regime allow that? I mean, I think we started off for this guide by saying this is not a resolution regime, right? Resolution regimes would provide for your bailing and other tools, but here's a regime which we believe would work for banks that are not subject to that. Although we went back and forth on really at what point can you clearly say that a bank is systemic or not systemic, and therefore should be subject to resolution only and or liquidation only. And as Ruth had said earlier on, in some cases, liquidation is actually a tool in resolution, so that those conversations would continue. Again, the treatment of deposits as a key claim or liability on the books of the failed bank is key, and you just heard very interesting conversations. When my former IMF hat, depositor preference seemed to be very normal. And then I've discovered in the last couple of years that it's not always as simple as that. So one has to discuss, as part of the funding, how do you treat depositors in the creditor hierarchy, and if it's for a systemic bank, again in resolution, may be a different approach from if it's not so systemic. But then again, from a public policy objective standpoint, confidence in the banking system is always going to be critical, right? And so you may succeed in dealing with Bank A that has failed a particular way, but one always has to think of how the remaining banking system is going to hold. And so this is going to be very important, how deposits are treated. Now, ideally, in jurisdictions that have an ex-ante funded deposit insurance scheme, I think the conversation is not as complex because you already have a mandate for the deposit insurance scheme. It could be as simple a mandate as a payout, or it could be more complex as a loss minimizer or a risk minimizer. But having an ex-ante funded DIS, which is ready and able to fund a liquidation, is always a good thing to have. And then ideally it's able to pay out claims as quickly as possible to insured depositors. And then there are times when the DIS may need a liquidity, an emergency liquidity backstop, also hopefully already prearranged, either from the fiscal authorities or in some cases from the central banks, from anywhere else, from the market, anywhere else that is available. Now, it's going to be important to look, if there's a DIS, then what is the coverage of deposits that are insured? This could be the type of deposits, SME deposits versus retail, household type deposits, large deposits. In some countries, it comes down to the currency involved. And then there are all these cross-border considerations, right? If a foreign bank operates a branch in jurisdiction, then what are the considerations? All of these could look very simple before bank failure, and then while a bank failure is going on, what has been even set out in legislation that seems quite reasonable may seem very impractical. And so it becomes a challenge for policymakers and resolution authorities as to how do we use this DIS in a way that still keeps the banking system holding. And then the additional question of mandates of the DIS. If it's able to only do a payout, that sort of constrains the options available to the liquidation authority. And I think this morning we talked about optionality, the extent to which the DIS can be flexible enough to also support other tools, including transfer of assets and liabilities, P&A, mainly either to an existing acquiring bank or a bridge bank, is going to be very critical. There are I think from the survey that UNIDOA had conducted, there are jurisdictions whose DIS mandates are limited only to payouts. And so while the resolution authority or the liquidation authority may have options and tools to use in liquidating banks, funding of those tools becomes a problem because the DIS is not able to contribute to a P&A, for example. So ideally, flexibility on the mandate of the DIS, although that's a bigger conversation, really, in many jurisdictions, because there's a lot more involved in just changing a mandate of a DIS. It's also about the capacity and how established and mature the fund is, and etc. And then there could be other quantitative constraints on the use of DIS, including how much is available, even if it's able to fund other tools. It's also a question of, the least cost considerations sometimes, and really how much is limited to how much it would have to pay out if it did a mere payout, and so what are the constraints? And so more or less, there sometimes is a residual gap after you've done all of this, assuming you even have a DIS in place. And jurisdictions need to think of how do you deal with any residual gaps that come up, and ideally before you need to ever use it. But there's a very interesting aspect to this that I really wanted to bring up, and this has to do with countries where a DIS is not available at all. And as much as we like to think that a DIS is quite staple in all jurisdictions, it really isn't. And in the emerging market, developing economy context, and even in some G20 countries, I might add. I understand that New Zealand, for example, still doesn't have a DIS, and South Africa just launched a DIS in April of this year. I remember working at the fund and being part of the South Africa FSAP in 2014, and us trying to explain why DIS was important. It wasn't an easy conversation. Eventually, they've set one up. So there are many countries where DIS don't exist. The World Bank had a survey, I think in 2014, just 10 years ago, where out of 189 countries surveyed, 112, which is 60%, had no DIS at all. And then you have DIS that are very small, and have not reached target size, and yet have to deal with a bank failure. And so for jurisdictions like this, you want to ask yourself, what really are we dealing with? If it's systemic, hopefully you're dealing with resolution tools, but still you need funding arrangements sorted out. If it's not systemic, clearly not systemic at all, then you have the luxury of saying, you get what you get out of the liquidation process. And that could wait, that could go on. If it's a court-based system, it could go on for a very long time. If it's administrative liquidation, it could be maybe shorter. But still, you have a situation where depositors may have to go home with nothing. You shake up the foundations of your banking system, you may deal with that or not. But there's often the tendency for public policy to step in, for fiscal authorities to step in at that point to say, we're going to do something about this. We do not have a DIS, we do not have a resolution fund, and therefore we're stepping in to do something. The fiscal authorities must themselves have the fiscal space to do this. And if they do, then one has to think of how they structure the interventions so that moral hazard is reduced, if not completely eliminated. How do they recover what has gone in? How is the selection made? Who gets what? Who gets, which other liabilities get bailed out, if you will, or not? And then, more importantly, what is the cost to the taxpayer? Right, and these are very important conversations that go on in certain jurisdictions. I myself have been in the middle of this from Ghana, where in 2018, we had to deal with a systemic banking crisis with 9 banks eventually closed, without a deposit insurance scheme. And we had put in the resolution framework in 2016 with all the tools, right? All of the FSB key attributes tools. So we were resolution ready in that sense, but not the financing part of things. And we had no DIS. But the systemic nature of the crisis was such that when it had to be dealt with, the taxpayer had to intervene. The fiscal authorities had to intervene. Something in the neighborhood of 5 to 10% of GDP was the cost to the taxpayer if you added the interests that the government had to bear on the bonds that were issued. And all of this was to fund P&A to acquiring banks. One of those acquiring banks was already existing, a state-owned bank, but then a bridge bank was set up to acquire the deposit liabilities and the very few assets of the other failed banks. And then the gap was filled by government bonds. As we speak now, those bonds have been restructured recently because government went through a fiscal crisis. And the IMF insisted that government's debt was not sustainable. And so it had to undertake a very extensive debt restructuring, not only of Eurobonds, but also of domestic currency bonds. And so these same banks also have taken another hit. So this is the classic example of the sovereign bank nexus, right, which we all know about intuitively. So the question really is, while the rest of the world tries to catch up with GIS and other ex-ante, nicely designed financing arrangements for bank liquidation, these things are happening already. And there's a big conversation from a global cooperation standpoint as to how do we get countries ready. Some of these countries I've talked about that have no DIS are jurisdictions where GSIPs operate, right, with very systemic presence in those jurisdictions. And so I think that it's something that should be of interest globally, and we'll have to find solutions to this. Thank you.
Okay, very good, very interesting and complementary perspective. There are some fundamental issues we take for granted, actually. It looks like basically you have to look at those issues before you get into these nice technicalities, right? How to improve our banks' insolvency regimes. But here the question, Elsie and the others, is how much of these considerations could actually be introduced in the exercise that you're conducting? To what extent you should actually take into account those financial stability considerations to inspire some aspects of the reform of the banks' insolvency regimes that you are proposing? We should keep financial stability issues completely separated from this exercise?
Actually, if I may, Fernando, it's a question I wanted to ask Elsie, because it was her who actually made a point which I believe applies across the globe to many countries, which is makes a very poor case for a court-based system, because in developing markets, it's very likely that pretty much any bank can become systemic, because it's maybe the only bank lending in a rural area. There's no one else that can do it, and then that can disrupt the supply chain. So then if we take into consideration the supply chain and the real economy and link it with bank risk, because now everything is linked in the supply chain, and the producers are there and the buyers are here. So ultimately it can end up creating a crisis which is difficult to contain. So in countries where any bank pretty much can become eventually systemic, the financial stability issue is ever present, and therefore the distinction between resolution and liquidation makes very little sense, and the distinction between an administrative system and a court-based system is even less, because in those countries it's not infrequent that the court system doesn't work very expediently. So it's very muddled in that sense, and wouldn't the result of that be, perhaps, and this is outside the guide, that the magic word, although it might undermine predictability, but I don't think so, is flexibility?
Absolutely. Absolutely. And I think this is a point that made from day one of the work that we do.
I've heard too many times the word flexibility.
And
in the Conference of Legal Experts. I'm really impressed.
Yes. So, I mean, basically, in Ghana, we have a single track arrangement where every bank, every deposit-taking institution, and that includes even a cooperative bank or a savings and loans company, is viewed as potentially systemic at the point of failure. Because it's such a fragile financial system, and it's very interrelated with the macroeconomy. And therefore, it's very difficult for us to understand how you can say that a bank or deposit-taking institution may not be systemic. And indeed, we take the view that that's the reason why banks are special. They're not like any other corporate entity, right? They're risk machines. They're risky, and they're potentially very systemic anyway. So we have that approach, and we're not the only countries that do that, by the way. But yes, if you have a different approach for a different way of looking at so-called non-systemic institutions, I think there are a lot of examples, including the recent SVB case that shows you that ultimately flexibility is required. So prepare as though you're dealing with everything being systemic, and have, I think it was Ben who told us that he didn't have a resolution plan for SVP. He didn't even know about it, right? So prepare as though everything could be systemic. And then if at the point of failure they're not systemic, even better, right? Yeah.
What is the other way, right? But anyway. Ruth, you wanted to come in?
Yes, I mean, I think flexibility, but flexibility with appropriate governance and accountability. I think this is essential. So in those kind of single track regimes that we're talking about, there's usually some kind of officially, provided in the legislative framework, governance procedure for moving up to the recognition that a situation is systemic, which brings on board additional funding and additional tools. But there's a procedure there. Equally, I mean, within the deposit insurance, there needs, if the deposit insurance is going to contribute to funding a liquidation, there are normally financial caps there. If you're going to exceed those, whether it's a systemic risk exception, whatever, there's a procedure for that. So I think flexibility constrained with appropriate governance is the way that one needs to go. Maybe I'm being too British with that.
Safeguards are very important.
You like the systemic exception approach, right?
I think the systemic exception approach is one way to do it. The other way that sub-countries do it is with their deposit insurers, and they have a fairly flexible way of calculating the cap on the amount that can be used. And I know this is an issue that's coming up in discussions within Europe at the moment as to how you're calculating that, what costs you take into account, and where you have some kind of ability to take into account indirect costs, systemic costs, then that gives you a lot of flexibility, a lot of leeway. My concern is that the governance isn't there, and maybe a systemic exception is the better way to do it, because there you do have appropriate controls. But that's just one view.
Great. Let me invite the rest of the audience to participate in this debate. Any other question? Or maybe you want to, David, to come in here?
Just one point that when it comes to dealing with systemic aspects, one key issue that arose is that we did not want to be seen as overstepping on the key attributes. So that's why we try to leave all these aspects out of the guide. That doesn't mean that those aspects are not relevant. It's just that we are dealing with a specific subset of banks. That we refer to, the distinction of systemic versus non-systemic is not something that we set in stone. We rely on the systemic at the point of failure. If something is systemic at the point of failure, then of course you are in a different scenario, and then you may deploy other tools. So that's something that the guide does not is not against. Is simply that the guide is not the instrument to cover that. There are other instruments to cover that.
That's a fair point. I mean, it is consistent with the scope of your exercise and the objective that Ignacio was stressing before, that not stepping in the territory of other standard setting bodies. Maybe the same could be applied actually to what you say about the functions of these deposit insurers, right? Because you have the IADI principles, and the IADI principles are compatible with different actually mandates of deposit insurance funds, right? So you cannot actually sort of now to say, well, the IADI principle should be reformed in this or that particular way. This is not your role, and you want to be respectful with that.
No, IADI was an active participant during the discussions.
Yeah, of course.
Fernando?
Yes,
I
Elsie,
may
please.
just chip into what David said. David, I think you're 100% right about not wanting to overreach to FSB key attributes, so we try to steer away. The more important thing is, even though we all agree that at the point of failure, a bank could be systemic, and therefore a systemic risk exception might apply, whatever it is. From a crisis preparedness standpoint, it's always important to see how the authorities are prepared. Because at the point of failure, it's usually too late to start planning, right, for how you deal with it. And so it is really about the whole psyche of regulation, supervision, crisis preparedness, to say who's in the perimeter for the use of certain tools, what kinds of funding arrangements are in place, and do we know each bank well enough so that at the point of failure we can quickly trigger or roll out
That's a resolution
a plan.
planning idea, right?
Well, sort of. There's a sense in which there's got to be some level of planning, even where you feel like a bank may not be systemically important, although at the point of failure it could be. There's a sense in which perhaps then there's got to be some light touch planning, right? From a very practical, I'm just being very practical, because at the point of failure, it's late. You have been holed up all day and all night trying to find a solution. And sometimes the governance arrangements at that point may not be the most optimal. Right, so just something to think about. This is just very operational.
That was another aspect that was extensively discussed, whether to introduce, the idea of planning even as an optionality, and then it was decided that it could be seen as too prescriptive. So what we left was contingency planning, and that was all we could.
Okay.
Because
we could be left with.
If I may add to it briefly, some people in this room, Marco, Barcius, and others, presented a paper in this room talking about proportionality in regulatory requirements and excessive planning requirements for very small banks is perhaps too much of a burden at some point. So you actually maybe overdoing it. So it's difficult to find the adequate balance. I see Marco very silent, so I'm very surprised.
Planning was a fair compromise.
Okay. Very good. Please, come in.
Thanks a lot for the presentations. I had a question whether the group had discussed beyond the implications for banks. I understand the scope of the guide was a bank liquidation tool, but perhaps many of the discussions would also apply to other regulated entities within the financial sector. And South Africa was mentioned, and I know within the scope there's payment system operators, for example, that don't undergo a license for banks. Would some of the discussions or implications of the guide would potentially also apply to other regulated institutions within the financial sector? Thank you.
Absolutely. So this was a methodological issue. We had to decide what to stick with, essentially, and we thought that we could move forward with the legislative guide that was applicable to banks. Now, if you get into the issue of the perimeter, then you start getting into shaky ground because the perimeter may be defined differently in different countries. So by sticking to entities regulated as banks, then you can provide for a core criteria that work for these type of institutions. But countries could be free to decide whether they would want to use the legislative guide as an instrument for a broader scope that could encompass other types of entities. But that is, again, a legislative choice for each jurisdiction, because it very much depends, and this is something we realized early on, it very much depends on the landscape, regulatory and market of each country.
Thanks a lot.
Great. More questions, comments? If not, okay. So let's.
This one.
There's one there. Roberto.
I'm here, just behind the corner.
Sorry, yes, you're Roberto.
Thank you, Fernando.
Another Spaniard.
So I was thinking that I understood from you that the guide is not advocating for any particular approach in terms of the single track approach versus the dual track approach. But listening to you, it seems to me that in practice, some advantages are found regarding the single track approach compared to the other one. Because on the one hand, you are saying that administrative type of procedures are preferable for the reasons that have been explained at length. Then, of course, you can decide which should be the authority with this responsibility. But if you already have one authority dealing with resolution that would apply in practice very similar tools, it would not make much sense to create another authority or to vest this in the supervisory authority or to someone else. And then, if finally we are of the view that we need to keep flexibility because the determination of whether a bank is systemic or not may change actually in the very last minute for the reasons that we learned even this morning at the point of failure, to retain this flexibility could be better to have just one authority dealing with all the cases, that deciding and preparing better for all the cases, and in the end decided whether to use the resolution framework or the liquidation framework depending on the circumstances. Am I correct in this understanding, or I'm reading too much?
I'm not asking that, answering that.
I would just say I think that's an inference that it's reasonable to draw. The guide doesn't say anything explicitly about that, and wouldn't. I think we have to be realistic. We're not expecting people to completely rewrite their legal framework. But if you want to think that, there's
Yeah.
It's reasonable.
and just to complete that there's also a specific mention saying that single-track regimes may find some of the advice in the legislative guide perhaps superfluous. Superfluous because they already have those elements, and we refer specifically to the chapters that contain the specific advice. We are clear on that. Still, I mean, there are certain operational aspects that may also be useful for single track regimes, and we include them because they go into some of the nitty-gritty of the process that may be left out if you are simply transposing the key attributes which are relatively high level. So to that extent, it may also be useful to single track regimes. But yes, I fully concur with what Ruth said.
Very good. So you have to read very carefully, not only all lines of the report, but also between lines, right? Great. Okay, I think that we can adjourn this session. Thank you very much. Thank you. Ignacio, David, Ruth, thank you for your questions. I think since this is the last session, I think I should probably say that we are very grateful, very just on behalf of the participants. Thank you very much. Thank you very much, Pedro, for hosting us. I think it has been very interesting conference, and have learned all quite a deal.
And send comments.
Yeah.
Send comments.
Send consultation.
Yes. And send comments to the consultation report. Yes. Sorry.
Thank you very much. Thank you, Fernanda, and to all our panelists. Now we're sadly coming to the end of the SRB Legal Conference, and a special thanks to all of our moderators, speakers, and of course you in the audience here and online for your attention and your contributions. And if you want to relive the day, the videos will soon be available on our website and on our YouTube channel. Let's now turn to the concluding remarks. I bring apologies from SRB Vice Chair Jan Reinder de Carpentier, who can't be with us today. So let's invite SRB Board Member Tuija Tauas to the stage to give us some final conclusions. Tuija.
Okay. So good afternoon, everyone. So this is this extremely interesting SRB Legal Conference is now coming to an end. And I would like to start by expressing my thanks to all of you excellent speakers and panelists for your presence and for your contributions to the 3 panels. And thanks also to our audience today, both of those who are remote and who are here in Brussels. And I have just learned that we are altogether 750 participants, which is a great number, I think. And finally, I would also like to thank our General Counsel Carl Philipp Wojcik for ensuring that we had this amazing day today. Thank you. And of course, the gratitude goes to all the staff members at SRB Legal team and communications and all the others behind the organization of this event. So we all know that today's conference has been taken place in a moment where we see major developments in the EU and across the globe on bank resolution. And indeed, throughout the day, we have been navigating the frontiers of our legal and judicial framework for banks, but also operational frontiers stemming from EU and national legal particularities. So coming back to the question from our chair, Dominique Labreux, in his opening words, I think that the heading of this conference has been very well crystallized. But let me turn to the content and outcome of today's conference. In the first panel, we discussed the legal aspects of resolution transfer tools. We all know these transfer tools are essential for bank resolution, and transfer tools have been widely used in the past years. However, during the discussions, we also stressed that the challenges we have to use the transfer tools. For example, challenges in setting up a bridge institution, not in US, but everywhere else. And challenges because of multi-jurisdictional and fragmented market. And the recent cases have also shown the need to improve these tools so that in a crisis case they can be used in an agile manner. And this is extremely important for us resolution authorities, that we have this flexibility and optionality in different scenarios where we are working on ad hoc basis. This first panel also touched the challenges arising from digitalization, like the speed of deposit runs, but also the opportunities of digitalization. Digitalization can help us in the application of resolution tools more effectively. For example, we can have better access to data, we can have better access to documentation faster, and it can also streamline possibilities for communication. So let's go to the second panel. In the second panel, we talked about international investment arbitration and how judicial protection of investors and investor protection on the basis of bilateral investment treaties can coexist with, in the context of bank resolution. Here the panelists have presented their views and very interesting update on jurisdictional and procedural issues across EU courts and international arbitral tribunals, including the risks of concurrent proceedings, the scope of review of EU courts of arbitral awards and their recognition and enforcement within the EU. So very interesting but difficult topic also. This brings me to the third panel, where you have looked at the legal challenges for dealing with small and medium-sized banks, and taking into account the often very divergent domestic legislation of EU member states and beyond. Here you presented the main elements of the work done in UNIDROIT, and you addressed the existing gaps and the wish to enhance the harmonization among jurisdictions. And I think there was a very interesting focus on the important role of administrative authorities in bank liquidations. And here we also heard about different institutional models and main aspects of insolvency regimes, and if there is no deposit, and the challenge is if there is no deposit insurance fund, like we just learned. So very interesting panel also, thank you. So ladies and gentlemen, I would like to conclude by emphasizing the importance of open and frank discussion of these legal questions. This is fundamental to our legal framework, how it works and how it develops here in Banking Union, but also internationally. And throughout the years, SRB has always worked to further improve the understanding of the legal framework and contributed to its implementation. However, the legal framework is not static. As we've seen in the last panel, it will keep developing at national, at EU and global level all the time. So that's why it's so important to continue interacting with our stakeholders. And I think this SRB Legal Conference allows well for this open discussion and dialogue and sharing experiences. And if you didn't know, the past two conferences have given rise to a dedicated publication. And so the debate continues there in the form of publications. So in that sense, the SRB Legal Conference is a real lighthouse event charting the course of policymakers and lawyers. So thank you everyone once again for your participation. And we already look forward to our next legal conference. And I had the privilege now to announce that we will be organizing this next legal conference in the spring next year already. So, and yeah, like Fernando Resto just said, I also wish that we can see in that next conference, next spring, what the CMDI negotiators think about deposit preference or resolution of mid-sized banks. And I think that would be a nice present also to the single resolution mechanism, which will celebrate 10 years anniversary next year. So safe trip back home to those who came to Brussels for this event. Thank you.